My everything is you, Lord. Yeah. Ha-ha. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express
my gratitude
for all the many things?
all the many things you've done for me?
Words are not enough,
Words are not
yeah.
enough to say thank you.
Say, Lord, you are my everything.
You're
One
my
more time.
everything.
How can I express my
How
gratitude
can I express my gratitude
for all the many things,
all the many things you've
Father,
done
you
for
done for
me?
me, yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my
Say,
everything.
I call you
Oh,
Jireh.
you Jireh. Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
Lord, you're my everything.
I call you Jireh.
Oh, you Jireh. Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
Another Saturday is right here with us, and we're pleased to come your way live on BWTV with the program The Community and the Law. The new 10-year long residence route will no longer accept overstaying tours the qualifying period. What is that talking about? We'll delve into that and get the answers and, of course, the explanation from BWF Solicitors. The senior partner is here. So I welcome you once again to The Community and the Law. Let's delve into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome to another Saturday. It's the very third Saturday of the month of March 2024. My name is Oreku Frimpon, and I'm privileged to be hosting the program The Community and the Law, brought to you by BWF Solicitors. We live on all social media platforms at BWF Solicitors and at BWTV. Now, we are going to, for the next 2 hours, engage you in a very solid discussion. Now, things keep changing every day. It's like technology. The next moment you look at what you have in your hands and it's changed from what you had previously. The laws are changing, the guidelines are changing. There are updates every day. And today on the program, we're going to look at several of these updates and also get you to be up to date. The new 10-year long residence route will no longer accept overstaying towards the qualifying period. What does that mean? That is our main focus of discussion this afternoon. So please stick and stay, and let's say thank you to our benefactors, BWF Solicitors, our trusted partners when it comes to the law. They are on the 4th floor of the Anna House, 214 to 218, Tottenham High Road, Seven Sisters, North London. They work Monday to Fridays between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340. The number again 0208 493 7340, or the emergency number 077 127 61884. Now, BWF Solicitors brings us this educational program to help empower you and also get you to understand the various things that go on when it comes to the law. And today we are privileged once again to have the senior partner of BWF Solicitors come join us on the program to help us look at the updates and also answer the question I have posed, whether the new 10-year long residence route would continue to accept overstaying towards the qualifying period. So, ladies and gentlemen, brothers and sisters, aunties and uncles, papas and mamas, everybody, let's welcome the senior partner of BWF Solicitors, Mr. Bernardo Usu, Uncle Ben, we call him. Uncle Ben, good afternoon.
Oh, good afternoon, Kwaiku. It's always a pleasure to be here serving the community. And it's always a pleasure to also have you. On behalf of the community, we say thank you. We go back, I'll say at least about 2 decades now.
Yes.
I had Dr. Mark in my office yesterday.
Okay.
And we're looking back to the partnership we've had. And it goes back to, I think, 2017. For us, as I always say, nothing gives us more delight than having the opportunity to speak to the community.
That's right.
And make an input into our lives. And that is what really drives us. So I'm always glad to be here.
Thank you so much. And I am also very honored to be serving the community through your platform, because when I go around and people see me, oh yeah, you look like a lawyer. Yes, I'm not, but I've associated myself with the very best. So definitely when we get the opportunity to serve you, we're so privileged. Well, ladies and gentlemen, we're going to look at the various updates and all the other bits. But as Uncle Ben has given us the props, well, let us also acknowledge the support they give us. BWF Solicitors.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for joining me to say thank you to BWF Solicitors. Remember, if you're going by public transport and you want to visit them, you go on the Victoria line, get off at Seven Sisters, use exit number 2, and that will take you to the frontage of Anna House. Go up to the 4th floor. That's where BWF solicitors are. You want somebody to help you interpret the various application and the immigration documents you have. BWF solicitors is ready to help you. If you want a representation in court, talk to BWF solicitors. If you want an application filed for you, appeals and all the other bits, talk to BWF solicitors. BWF solicitors 0208 493 7340. They have an office in Ghana, and the number is 055 589 5959. An emergency number, text and WhatsApp 077 127 61884. 077 127 61884. And today, as they continue to do that, and as they have always done, they are supporting us live on BWTV to bring you the community and the law, another edition of the program that brings you all the understanding you need to have. And today we have some very exciting updates to give you, and also to answer the question about the 10-year route and all the other bits around it. So get ready to learn, because I am ready to learn as well. Now let's look at some updates that were brought in earlier in the week. We're looking at the nugget that was given us from the beginning of the working week. Income from dependent children of migrant spouses may count towards minimum income requirement. If you've been following this program for the past couple of weeks, we've been talking about the income requirement, and one of the things that have come up that we want to really point out to you is the requirement that, or one of the bits that will help you meet the requirement. And it says that dependent children over 18 years of migrant spouses may contribute towards the minimum income requirement of their sponsor and their parents to meet the minimum income requirements under the immigration rules. Their income should be factored into the minimum income requirement, quoted from ELTRP 3.2F of Appendix FM Immigration Rules. Maybe I will start testing your knowledge now. Remember, we have mentioned this in the last couple of weeks, and we've talked about how to meet the one that's moving from 18,600 to 29,000. How do you meet all that? What are the sources of income? And one of the things that Uncle Ben mentioned is the income from dependent children of migrant spouses. But listen, I'll go for further explanation. So we reiterate what it is that you need to do. Uncle Ben.
Okay, quickly. So, as you can see, the focus is on ensuring that our community will have the opportunity to reunite their families. And usually, the difficulties they have is in relation to maintenance and accommodation. Now, we've realized that within the next few weeks, maintenance requirement is going to go up. So, what we're doing as a firm is to see what we can leverage on to help the community for them to meet their requirements. The requirements are mandatory, and you can only meet it by the prescribed way, which will be the specified evidence. In addition, the rules makes way just like a motorway or you're going through a tunnel. There's always an escape route, and the escape route in this sense will be either the exemptions. Last week we talked about support from other people and GEN 3.1 and 3.2. Sorry, 3.1 and then 3.2. Those are also other exceptions. The other exception would be under what we call the passporting benefit. But this is a particular rule that people don't look at. For example, we've got a case here, and this man is going around other firms. His wife is here, but they're not. The combined income is not meeting. They don't meet the 18.6. But he brought his son with the wife. The wife has been here for 2 years. When the son came, he was 17. The son is now 19. He's been here 2 years, so he hasn't got settled. He's still a dependent. And he's working. In fact, he's earning over £10,000. If he adds that to his parents, they will be in the upper limit of £25,000, which means that they can bring their other child from Ghana, and then they will still meet the maintenance requirement. So what this is saying is that if you bring a child as part of your application as a partner, anytime you see E, it stands for eligibility. LT is leave to remain. So LTR, leave to remain. P is partner. PT is parent. So anytime you see E, it's telling you the requirements that you need to meet. So in this post, it's referring you to Appendix FM, which is the appendix for family life. Family life under the immigration rules is referred to as Appendix FM. It covers partners, parents, and children of migrants who are here on a limited basis. So the requirements are that the child has to be, 18 is no longer a child, but for this purposes, we'll still call him a child. So your child must be a dependent. And 2, the child must be over 18. These 2 requirements are mandatory. And who do we call a dependent? A dependent is somebody who's still on your application. So he's jointly with the mother or with the father as dependent on the main sponsor, and their income can always count towards the income requirement for partners.
Doesn't matter how much the person earns. I'm asking if, for instance, the person earns, say, £10,000 a year, and would that be enough to add up to what the parents do not have?
Okay, so if we take a typical parent and a child, so the child is 17, as I said, when they came, the partner will have to show an income of 18,600 for the partner. The additional dependent starts from 3,800. If you add 3,800 to 18,600, you will have 22,400. Any additional child will be charged at 2,400. So in this case, you ask whether there is a threshold. There's no threshold. So for example, if the father and the mother are earning 18,400, they have to be earning 22,400. They haven't met the threshold. So, but if the child is working and earning 10,000, they already earn 18,400. If it adds is 10,000, it's 28,400. They are way above that. So that is how you calculate it.
Well, that's the nugget for you. I know people are trying to call in. We haven't activated the lines yet, so just keep your fingers off the dialing pad, because we'll come to that later on. So what we're saying is that dependent children over 18 years of migrant spouses may contribute towards the minimum income requirement of their sponsor and their parents to meet the minimum income requirement under the immigration rules. Their income should be factored into the minimum income requirement. That is the ELTRP 3.2 of Appendix FM Immigration Rules. If you want any further details, please do not hesitate to contact BWF Solicitor 0208 493 7340 or 077 127 61884. Now let's see what further updates there are. Statement of Changes HC 590 has something we want to highlight. It states that the sponsor license application form and the sponsor management system will be unavailable from 7 p.m. on Tuesday, 2nd of April until 9 a.m. on Thursday, 4th of April. Annex A states that the Home Office will process as many defined certificate of sponsorship applications as possible before 7 p.m. on April 2, 2024, but any outstanding at that point will be cancelled, and a new application will need to be made based on the new codes and salary thresholds after 9 a.m. on April 4, 2024. This one I will ask you to call, but the main man is here. What's going to happen?
Well, so as you can see, between the 2nd of April, just after Easter, and the 4th of April, they're going to shut down the SMS, which is a sponsorship management system. This is a system that sponsors communicate with the Home Office, and when they're issuing COS and DCOS to people, this is where they issue it. But there's something key there, and it's of concern. My clients are very, very worried about it. Now, when you look at the second paragraph, it says Annex A states that the Home Office will process as many defined certificate of sponsorship applications as possible before 7 p.m. on the 2nd of April. But any outstanding at that point will be cancelled. So if you want to bring migrants from outside the UK, you need to apply for defined certificate of sponsorship. There's a difference between certificate of sponsorship COS and DCOS.
Yeah.
You have to make an application. For the past, I'll say about 3 to 4 months, Home Office have stubbornly refused to issue DCOS because the DCOS allows us license holders to bring people from outside. The COS is for people inside. So that one, the Home Office is not overly bothered about it because this will be people that already will have leave from the Home Office.
Okay.
So if somebody's made application, I've got a lot of clients who are waiting for their DCOS to be provided. They made the application, some of them November last year, some of them December last year, and some of them January last year, and they haven't got a decision.
Right.
We threatened to, shake the woods a bit, but I think my clients are saying, "No, lawyer, we beg you, hold on." We just want to, let them take their time. We are okay for now, obviously, if we need more. So if by the 2nd of April, you haven't received a decision from them, it means that from the 4th of April,
you have to make a new application.
Yes. Yes. And it's therefore significant. This is why. Maybe if we have time, I will show. There has been a change in the SOC, I will call SOC, which is a Standard Occupation Classification Code.
Yeah.
So the SOC, for example, for care workers is 6145. For senior care workers is 6146. Now they're changing the code. Some occupations have been taken out of the shortage occupation list and the salary list and immigration salary list. They've also changed the codes so that the code that you use for the DCOS, that code is changing. It's not only the code that is changing. Care, the income is moving from 21,000 plus to 23,200. So that is changed. So if you've applied for a DCOS, a defined certificate, based on £10.75, and you're still waiting for that to be approved, they cannot approve it because the income at that time on the 4th
will be more than what you have put on.
By the time you made the request, it was right.
So can somebody conveniently say that, well, between the 2nd and the 4th, there's going to be that transition. So if I have any application, I will not put it in before the 2nd, but rather wait and do it after the 4th.
Okay. Now, everybody who runs a business, and I sit down with my clients, I check what their needs are, how we can help them. And I'm very proud to say some of my clients are doing marvelously well. There's one I spoke to yesterday. He's doubled his turnover. We're talking millions, okay? And he's doing his work properly, meticulously, consistently. He's following the law. But he told me that he worries too much about this whole system. because his business is now based on migrants. So if this whole system collapses, he will lose all the contracts that he has with these other providers. And it's scary. What I tell my clients is that if you listen and you do as we ask you to, and you don't cut corners, you don't do fraud, you don't do wagadre, you don't do chininchika, but you listen and follow what we tell you, they can come any day with notice or without notice, you will pass.
You will pass.
So I've told them to relax. The issue with the DCOS is basically that the businesses are a bit more stable with migrants. Because when you're here, you're being sponsored by your employer for 3 years or 5 years. So at least for that time, he can forecast, plan, and budget. But when you have a homegrown person who clearly is doing this job either for vacation or because they want to go on holiday in summer, they want to earn £1,000 extra to buy their ticket. Once they finish the job, they're gone.
They're gone.
And
Yeah.
it takes them a lot to train these people to the level that whatever these people are doing, they are under supervision. So, for example, if somebody goes to a client's house and uses their fridge without a client's permission, it might look or sound innocuous to us, but it's a breach of their regulation.
Right.
And it may have to be reported to the CQC. That can affect their business because the council will say, you are not, deploying your qualified staff, and therefore we're not happy to work for you. So we're going to take our contract back. And quite cool. Potentially, we're talking about hundreds of thousands of pounds. All the people that I work for, some of these contracts are in their millions. So that's a lot of money for someone to use. So they like to have the migrants, train them over time. After 3, 4, 5 months, 6 months, 1 year, they become very competent. They promote them, some as coordinators or as managers. And it's very important that they put in an application way in time. Before this US, it took 24 hours for us to get a decision. Now it's taking months. We know why. We know because of the abuse and because they were sanitizing the system. I think they've pruned the system very well. And those who are not in the business of providing care to people, they've been pruned. And the serious players in the industry, they are going to be allowed to proceed. And I think we will see that from the 4th of April, before even then, those people who have applied for DCOS, they will have a lot of this. It will be approved, and because they will be doing a lot of checks, and the checks are still ongoing. Unfortunately, some people have had their license revoked because they were not doing the right thing.
Okay. Well, we're still picking up the updates and getting them explained as much as we can. So stick and stay with us. We're live on BWTV and we're bringing you the community updates at BWF Solicitors have helped us provide. The new 10-year long resident rules will no longer accept overstaying towards the qualifying period. That's our main discussion, but let's look at what the statement says. The new statement of changes in immigration rules will no longer accept overstays of 28 or less before November 24, 2016, or 14 days or less under paragraph 39E after November 24, 2016, as counting towards your qualifying period. This is a profound change in decades of immigration policy, which must be noted by all applicants on the 10-year lawful residence route. LR 3.2 HC590, Statement of Changes of 2024. Now, I'll hold on to this because that will be our discussion, and I'll pick another one and we'll look at who is a parent. The Statement of Change has brought out something about the definition of a parent. Now, it says that they have removed step parents in the definition of parent, even if the biological parent is dead. This is another profound departure from decades of old law, which included step parents in the definition of parents if the biological parent is dead. The change would adversely affect applications to bring a child to the UK. Do you read worry on my forehead? Let's go and get some explanation, Uncle Ben.
Yes, Kweku. I'm not sure what's exactly going on. As you know, we spend hours and hours and hours to go through these changes. Sometimes it can be very technical because when you're looking at the HC590, you're picking it to fit it in a certain room. So you need to make sure. The other time we're doing 3 laws at the same time. Luckily, this is just one law. So when you go to paragraph 6 of the immigration rules,
Yeah.
it says that parent includes step parent when the other parent is deceased. This new law, which is called Intro 7 of the HC 395, which will amend paragraph 6.2 of the immigration rules. Paragraph 6.2 is the definition side of the immigration rules, and you will see a lot of this. They sadly, why they've given us explanation, and I'll give you that later. Decided that a step parent is no longer a parent, and the reason they've given is that step parent is not always that step parents have parental responsibility. But we've always known this, and we've always known for many years in my practice. If the other parent is deceased, the step parent is also classified as a parent. So when you come to considering, for example, paragraph 297, if you go to the F, which relates to sole responsibility, if the other parent is deceased, there will be no need for those sole responsibility because the other parent here will qualify as a parent because it's a step parent. So you have 2 of the parents here. And I've always said where the 2 of the parents are here, then clearly sole responsibility doesn't come in. But they're taking it away. And they're taking it away, I think, in April. And again, if you have a child and you want to bring the child and the other parent is deceased, and you're married to a new partner who's a step parent, that parent will be the parent. And if you can make your application before April, we haven't got much time. I think it's the 6th of April. Before the 6th of April, then you stand a better chance of bringing your child. Else, we're going to have the sole responsibility within this, and it's going to be a big problem, challenge. But we will try and deal with it, and we will find the loopholes and discuss it in our subsequent engagements with the community.
My other question is, when they say they have taken the step parents from that definition, so then they are saying that you would have to at all costs prove sole responsibility, and that's a hard call, isn't it?
It is. So we know what sole responsibility is. And we've always been dancing on a head of a pin to try and define sole responsibility. I must say that when it comes to skilled migrants, the Home Office is not treating them very well. We shared the report from the Independent and the Guardian the other time, and the effects that this is having on children, including suicidal ideation. And those are the problems that we have. But if somebody has to meet sole responsibility, and the person has always lived here for a while, and at the time that they didn't have stay, they were not going to Ghana, and suddenly they've got their stay, they've also got another child. They haven't got the means to travel. They want to bring this other child. So responsibility always comes in. What I've always said is when you have a child and you know you're coming to settle in the UK, before you leave the child, you need to document what you're doing with the child, including when you're handing over the child to a guardian or to a carer. Because once you've documented this, the law allows you to show pre-departure and post-departure. So the pre-departure, sole responsibility, if you were actually looking after your child and you were the sole parent looking after the child, whatever evidence you have, it may be maternity records, inoculation records, school reports, church photographs, and other things, you can use that. There's a case called TD Yemen, which is authority on sole responsibility. In that case, if the courts and the Home Office were following that case, we would not have a lot of problems. But the way they assess the application is very convoluted. There's a case that I was involved in, and the Home Office were saying that, well, we are not even sure who your father is, because we've seen previous applications where you've given your father's name as A, and we've seen this application where you've given your father's name as B. Now, her real father is in another country. The person who purported that he was the father is not a father. We will find a way around. We found a solution, so we're working on it. But it makes the work very, very, very difficult. Very difficult.
All right. Well, if you just joined us, we're live on the Community on the Law and brought to you by BWF Solicitors. Now, I hear that there is something called e-visa. What is that? There's an update on it. Update your passports for your e-visas and travel from summer 2024 onwards. If the passport or national identity document you are traveling with is linked to your UKVI account, airlines and other carriers will be able to digitally check that you have permission to come to the UK. You should update your UKVI account with any passport you wish to use for travel to avoid unnecessary delays when traveling internationally. You can do this at www.gov.uk/update-UK visas-immigration-account-details. This is from the UK VIE visa. Now, when it comes to E and E and E and all that, those electronic stuff, what are we going to look at? An e-visa is an electronic record of a person's immigration status. Updating your physical document to an e-visa does not affect your immigration status or the conditions of your permission to enter or stay in the UK. E-visas remove the need for physical documents, including the BRPs. Listen, contact BWF Solicitors and they will help you, give you assistance or even explain the details to you. But once you are with us on the program, you're getting that privilege firsthand. BWF Solicitors, you can contact them at the on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters. You can call them 0208 493 7340. E-visas, UKVI asking all holders and to change to that update and all the rest of it. Let me pick up this one and I'll go to Uncle Ben for that explanation. The UK border and immigration system is becoming digital. This means that physical documents like BRPs and vignettes, visa stickers are being replaced by e-visas. As a result, the UKVI is asking all holders of vignettes and biometrics to create a UKVI account. You can get that from the website that I quoted. But Uncle Ben, e-visas. So does it mean that we have to put our physical passports and other things away because now we're going electronic, like on our mobile phones?
Yes, everything has been digitized all over the world. And I'm not sure whether you know this, but your NHS records is on your phone. Mine is on my phone once you've got the NHS app. That's what they're doing to visas as well. I think they are ensuring that their visas are becoming a bit more secured and it will be readily available even at the points of entry, including to airline businesses, because this is something new, but it's not new. It's not new because it started with some visitors in the Arab world, Yemen, Qatar, and some other countries. They're coming here with e-visas or e-visitors visa. So that's there. In America, they call it ESTA. Please, it's not Agnes and Esther. It's ESTA, ESTA.
Okay.
In America, it's called ESTA. It's an electronic visa. And obviously, if you go to America regularly, you will see that you have to apply for the ESTA and they approve it. They send you an email. You go online, you see the approval. When you go and they swap your passport, they will see that you've got an e-visa. That is what is happening. In fact, it started happening because we have received emails that some of our clients have been put on the system. So what I'm doing, and I started doing that yesterday, is that every client who receives a biometric card, we register them for this account.
Okay.
So the last one I registered was yesterday. Her details are not yet there because her card, her leave expires 2025, and it's an old style applications. Hers was done in 2020. The new ones, so those people who are getting their biometric residence card now, it's very likely that your details are there. When you receive the biometric card, there are two things that you can do. You can register with your passport or you can register with your biometric card. I'll always ask you to register with a biometric card because that's what was issued by the Home Office. So once I register them, I then hand over the running of the portal to them. So I change my mobile phone and my email and I give it to them so that they can run. EU people and their family members already have this account.
Okay.
That is why they can do share code.
Okay.
Yes. So they are already on there. This is for people on limited leave to remain, on indefinite leave to remain.
Well, that was the obvious question I was going to ask. That those with British passports and indefinite leave to remain, are they supposed to be doing this?
No, this is not for British passport, but it's for people who have indefinite leave to remain.
Okay.
Now, if your indefinite leave to remain is a wet ink, a wet ink is the one that they've stamped in your passport. You have double problem. It's not insurmountable. They've advised that you have to apply for a biometric residence card. I think it's free. You can apply for that, or you can go to certain places that the Home Office have designated for them to help you, and they will help you to register your details online. If you've got a biometric card as a parent of a child, as a spouse, or purely on private life, you can use your card to register. You can do that now, but sometime when you go, it will tell you that there's no current application on your account because they're doing that gradually. They're potentially dealing with millions of people.
Yeah,
so
obviously.
they're doing it gradually. And from this summer, when you're coming, they're going to swap your passport. And if you're one of those, you don't have to show your biometric card, you can come. You need to have a current passport. If your passport is about to expire, I will advise you to get a new passport, the 10-year passport, and that will allow you to be on the system for as long as your passport allows you to be. Anytime you change your passport, you have to change it online. But when you change, it doesn't reflect immediately because it goes through security check for the Home Office to assess and approve that this new passport, the person on there is the same person we've got in our system. How they do that, of course, they use your facials. And if you're doing an EEA application, it's so interesting. We use our phone to scan their faces, and you see that it goes around in colors. And then it scans the face. It's connected to the card. Without even inputting anything, it tells you this person is called Ekuya Tenewa. She was born in 1966. And it will tell you everything about this person. And that is where we are. We are digitalizing. I think UK is chasing Ghana. Ghana, we've already digitalized. So UK wants to get something like a Ghana card, but without a card. Obviously, your passport is what will be the gateway to that particular portal.
Right. Then finally, somebody asked me this question earlier in the week that the biometric card is expiring in December. Is it this system that is moving in that direction? Because we're told earlier that at the end of the year, nobody will have a physical biometric card.
So that is it. And as with any developed world, they don't wait till December and then they realize that, hey, we've got about 20 million people to put up. Because it's not only the people who are here with indefinite leave, but also the students, the workers, the skilled workers. These are millions of people, and they have to update all their systems and upgrade their system. So that even when you reach here, there's going to be a time that it's not even going to be your passport anymore. It's going to be facial recognition. And, if you travel to the UK regularly, you see that when you get there, you go through the channel, you put your passport, it scans your passport, and if you didn't sleep well, your face is contorted. It will tell you, no,
it's not you.
Do it again. And that's where we're getting to. And I think it's exciting. It's exciting because, you don't have to go and get so many passports to prove that you've been living in the UK. These are things that obviously is held in a secured place. And if you have the key to open your portal, because it's only you who can open it. If you don't hand your passport to the immigration officer, they cannot go into the portal.
That's right.
At the point of entry. So in Ghana, The airlines will be able to access that portal, and the Ghana immigration will also be able to access that portal. That is how unique this is going to be. That you're living here, but your details will be accessed from outside the UK. And it's quite interesting. All I will say is that there's no panic, but please don't wait. If you've got a biometric card, especially those who have the new ones this year, go and register. It's very likely that you will see your details online. Some will not see, like the one I did yesterday. She wasn't there. They said she doesn't have a current application. But eventually, they will upload the old application onto her portal, and then she will be able to access it.
If you want further details and assistance with all these, call BWF Solicitors on 0208 493 7340 or 077 127 61884. 077 127 61884. It's been updates, and that's the beauty of our association with BWF Solicitors, our trusted partners when it comes to the law. So for all immigration matters, so all your legal issues, when it comes to interpretation, when it comes to you having a question and you want an answer and an explanation, talk to BWF Solicitors. 4th floor of the Honor House, 214 to 218 Tottenham High Road. Let's say thank you to them and we'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and I'm happy to announce that you are there, and I've seen that you are there. But who is there, and how can I acknowledge you? Now let's see the few that are here. Nana Jumai, yes, you are here. Thank you very much. Please share, he says. David Lechu, hi. Hi, David. How are you doing? I know you're doing so very well. Sandra Fraser, good afternoon, says, good afternoon, Sandra. Thank you very much for doing what you do for us. Sandra Mateki Mate, good afternoon, Sandra. The next one is from Regina, who's saying hi to us. Regina, thank you very much for your kindness. Margaret Adu, Mensa, Antimagi, thank you very much. Good afternoon to you all, as she says. Kindly share and invite people, invite families and friends to join us on the program. Louisa Santiamwa, Honorable Brakwe Ku, and Uncle Ben. God bless BWF solicitors. We go to pick the next one. Anaya, good afternoon, everyone. Thank you. Good afternoon to you too. Lyrical Black. Good afternoon, Uncle Kweku and lawyer. Uncle Ben is here and he says hi to you as well. The Maya T Show. Good evening, all. Hand pink waving. Good evening, Maya T. Thank you very much. Remember, the Maya T Show comes off every Sunday afternoon between 3 and 5 p.m. UK time. And most of the time, you have Uncle Ben on there helping with God speaking brothers and sisters, and he explains the law to them as well. So you have the BWF solicitors helping us Saturday afternoon with the community and the law, and Sunday afternoon the Maya T show. So visit that or join that and share the pages as well. Debbie, Jesse, BW solicitors, we are ready to serve you. Yes. Debbie, how are you? I've said that I need you on the show, so get ready. I'm going to bring you. Oh, yeah. After your holiday in Ghana, I'll get you on the show. Hello, lovely family. That's from Tilly Duma, our usual sharer. And yes, she comes up to say, please kindly share, comments, and like. Let's go on to Kwache Pepra Alex. Do you have these on YouTube? Yes, Alex is on YouTube as well at BWF Solicitors and also at BWTV. So you can join us there. So when you get there, pick up the link, share, like the page, and also click on the notification button. Sally Fio, so share, please. Sally, thank you very much. Next, and Kweku has been one of my favorite presenters since 2000 and still the same voice. Bless you all. Well, Alex, thank you very much. It's by grace and the kind guidance from my senior brother, the senior partner of BWF Solicitor. Now, let me tell you one thing here. If you work with Uncle Ben and you don't look for excellence and quality, then you are not following him. So if I've been able to do that, let's say thank you to him as well, because he's been a very big pillar behind me. Onyamiye Obolo. Now, for those who don't understand that, he says that God is great. He's big. Fantastic show. Onyamiye Obolo, thank you very much. You've got us laughing here in the studio. Thank you so very much. We love you as well. Well, so let's look at the bit that's going to usher us into our discussion. The new 10-year-long resident route will no longer accept overstaying towards the qualifying period. Now, let me read what the statement says. It says it will no longer, the changes in immigration rules will no longer accept overstays of 28 or less before November 24, 2016, or 14 days or less under paragraph 39E after November 24, 2016, as counting towards your qualifying period. Now look at the days. 24th November 2016. We are in March 2024. We will be doing some calculations and there's some technicalities that I know Uncle Ben will unravel. Now, this is a profound change in decades of immigration policy, which must be noted by all applicants on the 10-year lawful residence route. 10-year lawful residence route. Let's look at what that is and why are we saying that they're not accepting overstaying. Overstaying as who, as what, and in what situation? The senior partner of BWF Solicitors is our guest and resource person, and I'll hand over to you, Uncle Ben.
Okay, Kweku. So today's topic, it's something that most people rely on. So when they make the application, sometimes the application goes to the Home Office. It stays there for months and months. It then comes back. It goes back again, and then they are given the status. Sometimes they make the application late, within 28 days, prior to 24th of November 2016, or within 14 days after that date. They will all count towards the qualifying period. The emphasis here are three descriptions. So we have lawful residence, we have continuity of residence, and then we have qualifying period.
Okay.
Lawful residence is just what it says. So when you look at this, for example, if we scroll down slightly, this is continuous residence. So click on continuous resident. Continuous resident. That's the first one. No, the first one.
Yeah.
Yes.
So show.
That's correct. Now, the continuous residence required is met if the applicant has spent the qualifying unbroken continuous residence period required by their root lawfully. If we go back again, they use qualifying unbroken continuous residence period for their root, and then they use the word lawfully. Why are they using these phrases? For us, if you go down slightly, it will tell you why. Go down. Let's go. Okay, stay there. Let's look at breaking continuous residence. Now, when you go to breaking continuous residence, let's pause there, right? CR, which is continuing residence 4.1. Okay? If we look at the DI, yes, I'm going to read it. An applicant's continuous residence period will be broken if any of the following apply. So A doesn't concern us, B doesn't concern us, C doesn't concern us. And then we go to D. Or the applicant does not or did not have permission. We've met our brother there again.
Yeah, or
there's unless there.
Unless.
That is a conjunctive word, which means that everything they've said above is nonsense if one of these applies. Let's go to I. It says the applicant made a successful application for permission to stay where paragraph 39E of part 1 of this rules applied. Or the applicant had permission when they left the UK, applied for entry clearance before that permission expired, or within 14 days of that permission expiring, and the application for entry clearance was successful. So we pause there. Go down again. Go down. That's enough. Okay? Any period without permission under CR 4.1 before 24th of November 2000 will break the continuous residence period unless what does it say? The period that you overstay is within 28 days. If you go down again, stop there. It says that the applicant had permission when they left the UK, applied for entry clearance, and that permission expired, and the application for entry clearance was successful. And then CR 4.3. 4.1D applies any period of time where the applicant did not have permission will be disregarded. What is 4.1D? Let's go up and go and look at 4.1D. Go up. What is 4.1D?
It says the applicant does not or did not have permission unless the applicant made a successful application for permission to stay, where paragraph 39E of part 1.
So it means that if you overstay for within 28 days, if the overstay was before 24th of November 2016, or after that your overstay was within 14 days. Let's go down again and let's see exactly what it said. It says where the applicant applying for settlement, the one that we just read. Yes. A, any period within permission under CR 4.1D before 24th of November
2016
will break continuous residence unless the overstay was within what? 28 days. Okay. Let's go to the new rules, and Adai will share that once. Let's look at lawful presence. Go down. Okay. Now, lawful presence. Kweku, I want you to read this.
CR 5.1 says the applicant will not be regarded as lawfully present in the UK under CR 1.1 A. During any period of imprisonment or detention under CR 4.1A, or B. During any period where they required permission and did not have it, unless paragraph 39E applies, or before 24 November 2016, the applicant made a successful application for permission either in or outside the UK within 28 days of the date their previous permission expired. Now, CR 52 says where CR 4.1 applies, the applicant will not be regarded as lawfully resident for any period during which those circumstances apply, and the exceptions in CR 2.3 to CR 2.5 will not apply.
Okay, so now you can take it off. We'll go to the next one, the one that is bringing us a lot of headache. Don't worry, I'll show you. So as you can see, you can count the 14 days after 24th of November 2016, or 28 days before 24th of November 2016. This is what happens. So somebody makes an application. They didn't pay the correct fee, so they told them, well, you have to pay the correct fee. Or they've made an application, they've applied for 2.5 years, they've gone to a different form, they've paid fees, IHS for, let's say, 2 years. It's possible. And then the Home Office writes to you and say that, can you pay the top up? And then you ignore them. Now, when you go to paragraph 39 of the immigration rules, it says that a valid application is an application that is made on the specified form, pay the specified money, and done their biometric card. So if you don't pay the specified money, your application is not valid. So you made your application in time, you were covered by Section 3C. This is very technical. That is why I was showing the law. Maybe when I show the final one, people will understand. We all know our Section 3C of the 71 Act. When you make your application in time and it goes to the Home Office and it stays there for a long time, even after months and months and your stay expires there, you are still deemed to be here lawfully, and that will count towards your lawful residence. If an application is invalid, it's not a decision, but it's rejected. Because it's not a decision, you don't have a right of appeal. So your Section 3C is stopped. And then you have 14 days, if it's today, to send the application back. If you do that, you'll be covered by paragraph 39E, because we've read that if it's within 14 days,
right,
it will be what? Disregarded. And it will count towards your lawful residence. And then we had a case of Hogo. The case of Hogo Court of Appeal, which went on and said, yes, everything Bernard is saying is right. So everything I'm saying here, the case of Hogo said is right. And then we have the case of Afzal, AFZAL. So AFZAL, the case of Afzal, went to the High Court, went to the Court of Appeal, went to the Supreme Court this December. And then the court said, no, this law that you're quoting, it's only a shield and not a sword. So the judges said 39E is only a shield and not a sword. How do you say something is a shield?
A shield, not a sword.
What it means is that if you make your application within the 14 days, you're protected, because it says any overstay should be disregarded. So if it's disregarded, it means that you were here lawfully. But the sword means that you're using it to achieve something. It will not count towards the qualifying period. So that if somebody came here in 2014, they came with 2.5 years, they didn't meet the financial requirements. So they went on the 10-year route. They renewed it. Their relationship broke down. So they switched to their child. They renewed and the last application, let's say the third application, she sent it. She applied for fee waiver. The fee waiver was rejected. They gave her 10 days to make the application. She didn't make the application within the 10 days. She made it within 30 days. It went to the Home Office. and then the Home Office gave her leave to remain. Or she made the application, the fee waiver was not successful, they gave her 10 days to apply, she applied within the 10 days, she didn't pay the IHS fully, they wrote to her and say your application is invalid.
Mm-hmm.
She applies again within 14 days, which will be covered by 39E.
39E. Mm-hmm.
So she comes to lawyer, oh, I came here in 2014. I renewed my visa. She's told you, the lawyer, that when I made my fee waiver application, they rejected it. And then within 14 days, I made the application. Everything is factual. And if you're not careful, you will tell her, oh, then you can do indefinite leave. And this is where I'm taking this.
Yeah.
Because on the face of it, she's been granted the application that they gave it to her. She made it within 14 days. So 39E should cover her. But the Supreme Court is saying that it is not a sword. Yes, it covered her. She didn't overstay.
But you couldn't use that period to count towards
the qualifying 10 years. So if the application that she made the last time went to Home Office for 6 months, if you add the 28 days that she, or the 13 days that she overstayed, she's overstayed for 6 months, 13 days. If she's applying for 10-year lawful residence and she counts that period, they refuse her and say that the new law and the case of Afzal says that it is a shield and it's not a sword. It's a phrase that we're going to hear a lot. And the new law, which Adai will show in a minute, clearly covers that. I think it's page 258 of HC 590. That should take us there. And as appendix, it goes to amend appendix LR. So when we look at qualifying period required for permission to stay on long residence, do we see the 28 days and 39E appearing somewhere? It is L 3.2.
3.2, yes.
Kweku, I want you to read that for us.
It says L 3.2 says the following periods will not count towards the qualifying period for long residence.
Stop there. When we read the other one, did it say it will not count? It didn't say.
It didn't say that.
It says it will be counted as lawful resident and it will be disregarded.
Disregarded.
But read again.
The following periods will not count towards the qualifying period for long residence.
So long residence is what? It's 10 years lawful resident. Why are they saying it will not count? Because of the case of Afzal, which is said that 39E is what? A shield
but not a
sword. Unfortunately, that is where we are. That is why we're treating this topic, because many of you will suffer. Many of you will be caught by this. And it means that the period that you overstayed, let's say the 13 days, which you thought that because it's less than 14 days, so it's been disregarded. Yes, it will be disregarded, but it would not count towards I could finish reading it.
Well, we're looking at the various subsections of that. A says, okay, so let me read it all together. LR 3.2, the following periods will not count towards the qualifying period for long residence. A, time spent on immigration bail, temporary admission or temporary release. And B, any period of overstaying between periods of permission before 24 November 2016, even if a further application was made within 28 days of the expiry of the previous permission. And C, any period of overstaying between periods of permission on or after 24 November 2016, even if paragraph 39E applies to that period of overstaying. And D, any current period of overstaying where paragraph 39E applies. And when there's this operative word there, and between all the four. So does it mean that the four will go together, or one of them will apply and disregard the other three?
So the end here is acting as an alternative.
Okay.
Because if you look at the first one, if you read 3.2, so the following periods will not count towards the qualifying period for long resident. So number one and number two, and number three. And
number
so
4.
they are all alternatives.
Okay.
Instead of using or, they've used and. You might think it's an addition, because if you're on temporary bail or temporary admission, before, if you make a successful application after that, it will count towards your lawful residence. And it's in the one that we saw before this. Now it will not count. Unfortunately, it's going to cause a lot of problems. Now, we've taken our time to educate our community. This week's nugget is on this subject, and next week we'll have a bit more time to explain. But if we take this off, this is what I want to say to people. What the judges in the case of Afza said at the Supreme Court is that if you make an invalid application, that is when you will encounter this problem. Because if you make a valid application, you're protected by 3C. Did you see 3C there?
No.
It wasn't there. 3C leave is as equally important as a vignette or leave to remain or leave to enter. So when you have a 3C leave, it means that your visa is expired whilst your application is with the Home Office. But the application was made within time and it was a valid application.
Okay.
So you need to be making a valid application. If you don't know the forms, please ask. It's so confusing. When people are applying for 10-year route on family basis because they are relying on their children, you cannot use long residence application. They're totally different. Now, the Secretary of State has realized that is a problem. So within this law, they've made provision that if you apply for indefinite leave, and it's on the basis of your family life, but you applied under Appendix LR, they should consider you under your family life. And if you qualify, they should give you under. So it's not a big problem. But there are instances where people apply for fee waiver. They don't get a fee waiver. They tell them to apply within 10 days. They don't apply within the 10 days. But their visa is expired. They've just got this. They've applied within 13 days. 39E covers them, but 39E will not count towards them qualifying. So you're here lawfully, but your lawfulness is a standstill lawfulness. So when you're counting 1 year, 2 years, 3 years, that break from the application to the consideration and approval will not count towards your 10 years.
So even if it's 13 days, you will have to wait an extra 13 days because
when it goes to the Home Office, it takes extra couple of weeks or couple of months. So that is the time that you have to take out of the 10 years. It means that it doesn't break your continuity of residence, but it will not
count towards that.
Very technical and unnecessary.
Very technical and unnecessary, but I would advise that don't get confused. Don't get it wrong. Don't get it twisted. Speak to those who know and know what to do. And I recommend that you speak to BWF solicitors on the 4th floor of the Anna House, 214-218 Tottenham High Road, Seven Sisters. 0208-493-7340 is your telephone number. You can send a text or WhatsApp to 077-127-61884. 077-127-61884. These are details of their services. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for sticking around. Now we're going to take your questions, we're going to take your concerns, we're going to address them. Uncle Ben is here, senior partner, BWF Solicitors is here. Remember, we're live on Facebook at BWF Solicitors, at BWTV. Remember, we're live on Facebook and YouTube at BWF Solicitors and BWTV. The lines are active now, 0208 493 7345. You can send a text to 07399 208468 and WhatsApp to 07950422780. Or you can go on to Facebook, YouTube, and go down to the comment section below and leave your comments there. We'll pick that one up and help you with that. Now, later on, we shall be doing our quiz where we test your knowledge of the kind of information we're giving you, so we find out that you are empowering yourself as we would want you to do. Now, let's see some of the questions that we have. But first of all, let's go. Whoever is on there, please hold on for me. I'll be back with you in a minute. Sally Field says, good evening, Uncle Ben. Please, I'm an EU with indefinite leave to remain, and I want to know the Home Office fee. If I made application to bring my partner, and also if I add my child before 11th of April, can you break that down for me?
Okay, so Sally, the Home Office fee, as we know, it's about 4,000 for people who are coming from outside. This comprises 1,000, just under 1,200 for the Home Office application, and for the IHS, which is the Immigration Health Surcharge, that is about 3,000 for. It's not 2.5 years; it's actually 2 years, 9 months. So that's how much you will pay. It's roughly about £4,000. That's your calculation. The income for spouses is 18,600. For an additional child, the first child is 3,800. You have to add that to the 18,600. And then the second child will be 2,400. So that will be added. So you have 18,600 plus 3,800. If there's any additional child again, and then it's 2,424,2,424. That is how you get your threshold or the minimum income requirement. Now, obviously, that is changing from the 11th of April. And from the 11th of April, the income requirement will be 29,000. There's no additional minimum income requirement for a child to meet. The 29,000 covers the family. Some people might say that, well, if you've got more than 4, 5, 6 children, then it's favorable. But obviously, not everybody brings their child. So it's quite steep from 18,600 to 29,000. Our advice, as we said last week, and Charles also did on Thursday, is that if you know that you're not earning close to 29,000 and you are not receiving a passport and benefit, and you don't have any compassionate circumstance in your case or an insurmountable obstacle, then please make your application before the 11th. Because even if you make your application before the 11th, you pay online and you haven't even taken your biometric, that's fine. Because once the application is gone, you've made the application. And that application must be successful for you to qualify under the old rule. So you don't make an application knowing that you don't even meet the current rule and say that, well, I'm earning 1,000, I'm earning 14,000, I don't earn 18,006. Banco Ben said, I can make the application. Once I've made it, no, that's not what I'm saying. What I'm saying is that if you're applying today, tomorrow up to the 10th of April, you have to meet the rules now.
No.
And the rules now is that you must earn 18,600.
Okay, so let's go to our phone lines and pick up the caller on there who has graciously waited. Hello.
Hello, good evening.
Good evening. Thank you for joining us. Uncle Ben is here. Can we have your question or concern?
Yeah. So my question is, if my qualifying child gets to 18 years and I am on the 10-year rule, before I get to the 10 years,
Mhm.
I still be qualified for to be on the 10-year rule?
Yes, Uncle Ben.
Yeah, I'm not quite sure. When you say qualifying child within the rules is a child who allows you to qualify for the parenthood. So they're usually British, have indefinite leave to remain, have EU SS limited leave, or have lived here for 7 years. So that is what you have to be mindful. Now, what do you mean by qualifying child?
So like my firstborn, she's the one that I use for my 10-year rule.
Yes, but what is her status?
But she has a British passport, but before she's got a British passport, yes, but how would I get to 18? How would I get to 10 years to do to get my indefinite stay whilst on the 10-year rule?
So you get to 10 years by counting the number of lawful residences you've had.
But I was thinking maybe they use the child to count for my 10-year rule.
No, they don't use the child. That would have been interesting, wouldn't it? No, they don't use the child. So you count the 10 years from the very first day you got your first lawful residence. When did you first get your lawful residence?
Oh, I had it about 2013.
So last year you did your 10 years. So why are you still waiting?
Yeah, I'm asking this question for a friend.
So it's not you, but someone else. Okay, so they have to count the same way you counted from 2013 to 2023. Ask her to count from a certain date that she became lawfully resident in the UK to the 10-year.
Yeah, the reason why I'm asking this is that my friend, her child is almost the same age as my last born, which who will be turning into 18 years by next year. But I know that she's got 2.5 years to, she's got like twice of the 2.5 years to renew. So when I count it, I think he might overgo the 10 years.
No. So these people ask this question a lot.
Okay.
When your child is under 18 and the child is a qualifying child, and the child, you rely on the child to get your 2.5. From there, although the child is above 18, you can continue to rely on the child if the child is still dependent on you. So even if they go to university, they stay at home and everything, you can still continue to rely on them. Okay.
Yeah, because this one that I'm talking about, the child has left the house now.
Oh, why she left the
Mm.
house when she's not 18?
I think there was a fight. There has always been a fight between that qualifying child with a adult sister. So they always fight. I think social people have taken that child that she has taken from the house.
Okay. Well, you know what? You can still rely on the child. If the child is under 18 and she's got direct access, she can still rely on the child. Okay?
Okay, okay, thank you.
You're welcome, my dear.
Okay, 0208493735 0739920848. Hello.
Hi,
Hi, good evening.
good evening.
Yes.
I have a question for you guys. I'm actually calling on behalf of my hairdresser. She's not very, she's busy at the moment. So
Okay.
I'm actually calling on behalf of a guy that works with her.
No
So
problem.
basically, she wants to know if the guy's a barber, but he came in as a student, and she wants to know how to get a code for the apprentice. I don't know if it's the apprentice scheme. You know the code that they get into work. You know, I don't know.
So
what it's
he
called,
came in as a student.
Yes, the sponsorship thing, the sponsorship code.
Okay.
Yes. Is it possible to change that? Because apparently the school is going to write to the Home Office to say that he hasn't attended lectures or something in February. He got a letter in February.
Okay. Agben, he's a student. The school is threatening to report him. He wants to change. Is there a code he can go on?
So what she's asking for is for the student to be sponsored by somebody who's got a sponsorship license. We talked about the standard occupation classification SOC code. So that's what she's talking about.
Okay.
Well, first of all, you need to find someone who has got the license to employ the person. There's so many occupations, even window cleaners. You can get a license to employ window cleaners. So just that our community don't use those things, we like to use some other thing. But he needs to find someone who is prepared to employ him. I'm mindful of the fact that his visa may have been revoked. I've just found yesterday or the day before yesterday that some employers are making the application for the people they are switching, and they are creating emails for them, and the email is then shut down, which means that when the Home Office revokes their visa, they send it to that particular email they use for the application. They don't have access to it. The employer doesn't look at the email because they only created it for the application. Please, I've got a case and I'm very upset about it because this person was given a minded to letter, which they could have responded and replied. They didn't because the employer has access to the email. They never gave it to them. So please, can he check that his visa has not been revoked? To do that, he can go on the Prove My Right to Work website as if he's applying for a share code. If he puts in his biometric card, if it's still there and it's not cancelled, then it means that it's not been revoked. But if it's cancelled, if it's February, normally they will give them 60 days, which means that March and April. But please ask him to act promptly because it may be that he revoked his right to leave.
Okay.
Yeah?
Okay. All right. Thank you very much for doing that on behalf of your friend. And if he has any challenges with doing any of those things, he could call 0208-493-7340 and speak to BWF solicitors. Okay.
Will do. Thank you very much.
Thank you. Enjoy your evening. 0208-493-7345. Let's pick up some of the comments from the platform. Whoever is called on, just please hold on. Akira McDonald says, how much do you have to pay if you are getting indefinite for your children? Migration and NHS charge.
So you don't pay NHS for indefinite leave. The fee is 2,885. Now, I hope I'm right. But that's a fee. 2,885. I may be wrong on the 85, but it's 2,800 and something. Okay.
Okay. On the phone, we have another caller. Hello.
Hello, good afternoon, Kwaku.
Good afternoon, sir. How are you?
Good afternoon.
Good afternoon.
Yeah, I have two questions. One is after you appeal for spouse visa refusal for the entry clearance, after you appeal online, how long will it take for you to hear first response from Home Office? And
Wow.
my second, yeah.
Okay, go on.
And my second question is, any update about Zamrano regarding Akesenya's case on the parent of British kids or whatever? Any updates?
If you're still waiting for Akisenya, then you're obviously waiting in vain. Yes, there has been a decision, but it doesn't affect the law. The court has said the Akisenya guidance, the guidance is unlawful. The guidance is unlawful. But the law is there. The law is untouched. So Akisenya is still Akisenya. Well, when you appeal, you do that online on a portal. And within certain days, the Home Office will have to share their bundle. So the court gives directions. The Home Office doesn't follow this direction. They do it as and when they like. The court doesn't do anything. If we don't follow it, they penalize us. So I would say that from an appeal to a court hearing, you're potentially looking about 6 months.
Okay.
Okay.
Okay. After the case, how long would they issue the visa? Let's say when you win the case from the hearing, how long will it take for you to get it? Will they give you issue the visa for your partner to come?
Well, if they don't appeal, then they should issue the visa within weeks, I would say, but sometimes it goes into months. And if it's delaying, you have to chase them. Okay.
Okay. Thank you very much. Thank you very much.
Okay. All right. Thank you too for coming. Let's pick up some comments from the platforms. There's one from YouTube. We could look at that. Queer McDonald, I think so. How much do you pay? Okay. I think you put it on both YouTube and Facebook. Thank you very much. You can also call in 0208-493-7345, 0208-493-7345. If you have any concern, let us know. So, Uncle Ben, if this period, 28 days before the 16th, November 2016 one, and the 14 days after that, if you put in an application and you don't factor in those days, either the 28 days before that date or 14 days, does it invalidate your application?
No, it doesn't. I mean, so it's going to act as a shield. So it makes your presence here lawful, but it doesn't count towards your 10 years. So what it means is that if you apply for 10 indefinitely prematurely, what they will do is that they will write to you and say, thank you very much for giving us 2,850 or 85, but you need to pay. You don't qualify for indefinite. We're happy to give you another 2.5 years. Please go and pay IHS, which is 2,500 and something. So they're not going to refund your 1,000 whatever, because the fee is 1,048. It's going up to 1,248 on the 24th of July. They're not going to refund that part to you. They're going to ask you to pay more.
Right.
And that's why you need to be careful. I'm not going to say that all indefinite leave applications, you have to go and see a lawyer. No, that's not what I'm saying. What I'm saying is that make sure that you know when you applied in time, when it was rejected, because some people applied for Zambrano. The Zambrano was rejected. They were given a right of appeal, so they still had a 3C right. They made an application in the 3C right, not 39E. Where 39E comes in is that you have overstayed. So it's not a 3C. When it's a 3C, you haven't overstayed. When it's a 39E, you have overstayed, but you haven't overstayed for more than 14 days or 28 days prior to 24th of November 2016. It's an overstay that doesn't count, because even if you overstay for 15 days, right? Or you overstay for 14 days. You made your application. It goes to the Home Office. They take 6 months to decide your application. When you're counting your 10 years, you need to take out 6 months, 14 days to count the 10 years. And that is why we're doing this subject, because else you're going to throw money away. They're not going to refuse you. They'll give you 2.5 years, but you have thrown money away. Yeah.
Okay. 0208-493-7345. Hello.
Hello. Good afternoon.
Good afternoon.
Please, I want to ask if you're on graduate visa and you want to do switching, can you add your dependent? Since the rules have changed, can you add your dependent, already in UK?
You're on what visa? Say that again.
On graduate route.
Graduate, also on a student visa. Okay.
Graduate visa, yeah.
So you're asking if you could add your dependents who are already here in the UK?
Yes, but since the rules have changed, I want to know.
So what is it? What is it switching to?
Who are already in the UK? Yeah.
So what are you switching to?
Skilled worker visa or no. Let me say that healthcare visa. Yeah, healthcare.
Okay, so you're switching from a student route to the healthcare route. Okay.
Yes, please.
And you want to find out if you could add your dependents who are already here in the UK, if you are successful. Okay, Uncle Ben.
Yeah, okay, cool. So this point is what caused the initial confusion when this law came out. And we said, even if you're here, it doesn't cover you. It doesn't cover him. It only covers people who are already
on the route.
Yes. He's not on a 6145 or 6146. He's on a student visa or graduate route visa, which is not a 6145 or 6. So the simple answer is that no. And this is a sad thing. The man has been here. He's been a student. He brought his wife. He's got a child, and he wants to switch to care route. Now he has to send his wife and his child back to Ghana. I mean, how unfair can this be?
Yeah.
How unfair can this be? And that is why there was that initial confusion, because it doesn't cover people like this. But obviously, there's a transition provision which covers those who are already on the route or have applied to be on the route.
Okay. All right. I think it answers your question. Okay. Let's go on to the other person that's come on the line. Hello.
Hello.
Yes. Good evening. Please go ahead.
Good evening. Yeah. Please. Actually, I have a question.
Yes.
My question is, I'm on the health. I came on a healthcare visa.
Yes.
I came on a healthcare visa.
Yes.
And actually, on my application, I didn't put on. I came and my dependent was having. No, my dependent was having a daughter, but unfortunately, upon application, didn't put a daughter on it.
Okay.
That we are here now. We are trying to bring the daughter of my dependent, and I don't know how we're gonna do it. If it can be possible, we can do it.
So both of you are here, but your partner's child is your partner's child is in Ghana. That's what it is.
It's in Ghana, yeah.
Okay, Uncle Ben.
Well, there's nothing wrong with it. I mean, your child is your child. As I keep telling people, if the child is yours.
No, I'm not the biological father.
Yes, I know, but your partner's child is her child. So the fact that she hasn't written on any forms, I mean, I've seen cases where both the Home Office and judges have used it against people and said, well, you didn't even put on your forms that you've got a child. Now you've provided DNA, so we accept that the child is your child. In that case, if it's going to be a problem, you need to get a DNA done, okay?
Hello?
He's listening to it.
Yeah, listening to yourself. Sorry about that. Okay, let's go to another person. Hello? Oops. Hello?
Hello. Good evening, Uncle Kweku.
Good evening, ma'am.
Good evening.
Please go ahead.
Please. Yeah, please. I have a question for Uncle Ben.
Yes, go ahead.
It's about my indefinite
indefinite leave.
Yes.
I still have 1 year. I still have 1 year in my card, but a friend told me that I need to register online. After this year, we are not using any card. But anytime I go online, if I put my date of birth and my card number, they said it's not matching their records. So I want them to help me. Any advice or something?
Is it one of the challenges we're facing?
Well, what if that happens? It means that she's entered something wrongly. I mean, I wish that I could help her. If there was a Zoom, I would have connected her and taken her through. It's a very technical. It's a very small issue. It happens to me sometimes. So when you put the wrong details in, that is what happens.
I think I've also realized something. Sometimes when you copy and paste details onto those encrypted sites, it doesn't recognize it because they want you to type it in so you show you are not a computer or a robot.
Yeah.
So what you could do when you copy and paste in there, delete the last digit or the last letter and type that back in and see if it works.
Okay.
Yeah, because sometimes it thinks that you are a computer.
Home office, but when you call them, nobody is picking up and all that. So I'm very, very confused. I don't know.
What residence have you got?
I have indefinite.
And when did you receive it?
4 years ago. I still have 1 year.
I know why.
20 December.
Yeah. So which site are you using to register? Okay. I'll try and share the site.
The actual site.
Yeah.
Okay. You keep.
I'm using the front because they will say enter your card number. Then when you turn the back, then they will say enter your date of birth.
Are you using your mobile phone to do the registration?
Yeah.
Are you using the app?
Are you using the app or are you doing it on a computer? Are you using the app on your phone?
Yes, please.
Go.
You are using the wrong process. You don't have to use an app for this. You have to go. I will share. Have you got access to Facebook?
Yes.
So it will be in the comment section.
Yeah, you will see. Okay. Once I die, takes the camera of me.
Okay, thank you.
Okay. All right. Thank you very much for. Okay. All right. 0208-493-7345. Let's see who's on the line here. I know today people have taken over the comments section on the phone. But still, let's do it. Hello.
Yeah.
Good evening.
Yeah, good evening, Uncle Ben.
Yes.
Good evening.
Thank you for the wonderful job you guys are doing.
Thank you too for staying with us. Yeah.
Basically, the last time I was listening to Uncle Ben, and I didn't really make this house. And I'm a family member of EU on certain status, but my biometric card expires in June. So about a week ago, I made an application just to switch to the settled status, like the card, basically like card replacement. Yeah. So am I supposed to? Because I heard EU nationals shouldn't do it because they're already on the e-visa already. So I'm trying to find out, would it conflict with my new application and just the new enrollment, or like kind of, I'm a bit confused. Or I should just stick to whatever I've done and wait for the card to come and automatically I'll be enrolled.
Do you have indefinite leave to remain?
Yes, please, I do.
Yes, so if you've got indefinite, it doesn't expire. Your card is what is expiring. I assume that you got your card a while ago. When did you get your card?
No, the card was pre-settled card. You get it? But when I had settled, I didn't.
They didn't bring you a card, because if you've got a pre-settled card, although they should replace it with an indefinite, they don't. So you have to physically apply for it. Yeah, you've done the right thing. You've applied for it. So
yes, please.
Your application should be on there. Have you tried going on your portal? You should be able to go on your portal with your passport.
I haven't really tried though. I haven't tried, but I've tried once when they gave me the decision. I tried, it was there, but recently I haven't tried though.
Okay, so if it's there, you've tried it once, it doesn't end. It says indefinite leave. So that's that. With the EU people, you always create an account before you make your application.
Yes.
Yeah.
So Uncle Ben, how do I check it? Do I what do I?
What did you use? What did you use to make your application?
I use the the app they have, the EU app.
Did you use your passport or your biometric card?
I remember. I think I used the biometric.
Yes, because if you are not an EU national, you can only use your biometric card. If you're an EU national, you can use your passport. So use your biometric card to go online. We're going to share a page now that if you share it, you can use it to go there. But when you go online, just go check my status, right?
Okay.
It should take you to the page.
Okay. Thank you very much.
Yes. No,
Okay.
this one.
All right.
Oh yeah.
0208493735. Now, those of you on the screen, you can see the website is .gov.uk/guidance and the online bit.
Hold on. How do I get an e-visa and a UK account?
Yeah.
Click on that.
So when you go on that page, you go to contents and it says, how do I get an e-visa and UK VI account? So it says, if you have a biometric resident permit, you that expires on 31st December 2024, we will tell you how to create a UK VI account and access your e-visa before the expiry date of your BRP. If you have already been contacted to create an account either by email or in a decision letter, you can now follow the instructions we sent you to create a UK VI account. If you have not yet been contacted about creating an account, you'll be able to create your account and access your e-visa later in 2024. So sign up for updates on this page to keep up to date when you'll be able to access your e-visa. You have permission to stay in the UK once you have created your UK VI account. You'll be able to sign into the View and Prove service to access your e-visa. If you have another physical document that is indefinite leave to enter or indefinite leave to remain, also known as settlement, and you currently prove your rights through a different type of physical document, such as a wet ink stamp, and Kabir mentioned that in his explanation earlier on, in your passport or a vignette sticker, then you should make a no time limit application. NTL application. If your no time limit application is successful, you get a BRP to prove your rights. You should carry your BRP along with your passport when traveling internationally. Once you have a BRP, you'll be able to create a UK VI account to access your e-visa later this year. Well, thank you very much. You go to .gov.uk and you have that detail. Hello?
Yeah, hello, Reku. Good evening.
Namayeti.
Papa.
Why are you not in the studio?
Sorry. Actually, today is one of my daughter's birthday, sister's birthday. So I'm with them having a little bit of fun.
Sweet mom and sweet 16. Well, let's pick your question because I think we're running out of time. Let's pick that quickly.
Thank you. A quick one.
Yes.
Well, I've got a friend who actually a student came with a student visa and got married to one of my friends actually. So what is happening now? This girl is really going through domestic abuse and she's asking if there is something that she can use the remaining visa on her passport to do something about, getting an indefinite or something. She's asking. I said, I don't know about that.
What's her status?
What is her status?
She's a dependent and she's going through domestic.
And what is the status of the person she depends on?
Married to a student. The student is still in school.
Oh, she's married to a student and she's going through domestic abuse. Has it been reported?
About twice, 2 occasions. Yes.
So at least she may have police report and some evidence about it, isn't it?
Yeah, she's even got evidence of medical report about some things and hate that she got from the husband.
Okay, Angwen.
Well, sadly, these things do happen. About a month ago, we did a topic on it. Thankfully, they've been added to the DDV, which means that they will get 6 months, and that is all they get. So she can get 6 months, but the 6 months is to allow her to put in a proper application. it doesn't lead to settlement because a partner is not one of the classes of migrants whose partners can acquire settlement through domestic violence. Usually will be British citizens, people with indefinite leave to remain, refugees, people with EU limited leave. She's not one of those, and therefore she can only get 6 months.
Okay, Oreku, if she obtains a divorce from Ghana, can she use that divorce to marry somebody else over here?
Well, if she's met someone she loves and she's free to marry that person, of course she can marry. But please, bear in mind that if you want to marry in the UK, your application goes to the Home Office for them to give approval. If at the time they realize that the person for whom you're here, you're divorced from the person, very likely that they will revoke your visa. My advice is that if she's from Ghana, once she's got a marriage certificate, she should use our tradition. Our tradition is richer, is better, and is less expensive. So she should get a customary marriage certificate from Ghana. Okay?
Oh, okay. So that means she can divorce in Ghana and then remarry in Ghana. She will use that to make an application over here.
She can divorce anywhere. Obviously, if it's a registry marriage, it has to be done in court. If it's a customary marriage and she hasn't lived here for 1 year, then it can be divorced or dissolved customarily. But if she's lived here for more than 1 year, then even if it's a customary marriage, it will have to be dissolved in court.
Okay, thank you, Uncle Ben. Thank you for that clarification.
Okay, thank you too, and happy birthday to our daughter.
I will tell her.
Okay. Well, with that, I am deactivating the phones because we've run out of time. It's about time we did the quiz. I know the phone lines are blaring and very hot this afternoon, but that's what you get from BWF Solicitors. A lot of very vital information. If you have any question, any concern, you can call BWF Solicitors on 0208-493-7340 or 077-127-61884. Now, quickly, Amma Wafa and her 17-year-old son joined their husband in the UK with a 2.5-year leave to enter from 2022. Their visa expires in June 2024. Amma has been told that they need to have an income of 18,600 from her or for her, plus 3,800 for her son. So that makes it what? 22,400. The sponsor income is 17,800, which is therefore below the minimum income requirement of 22,400. Yeah, my maths was okay. Her son works as a carer and earns £10,000. The question is, can she add the son's income to meet the minimum income requirement, that is a MIR? 3 answers. Choose from one. Yes, if he is a dependent and over 18 years old, you can. No, because the MIR is for Amma and her sponsor or partner to meet. 3, yes, because her son is part of the application. Get working. We'll take a quick break, and when we come back, we pick up the answers quickly and get the answer, the correct one, and the explanation from Uncle Ben before we draw the curtains down. It's still the community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, now we're back and we're quickly rounding up. So let's see what answers you gave me. Our first dilemma here is that she's been told that need to have an income of 18,600 for herself, 3,800 for the son. She earns 17,800, which is short of the requirement of 22,400. The son works and earns 10,000 pounds. Can she add the son's income to meet the minimum income requirement? Answer is 3. The day Parry says answer is 3. Okay, let's see what the next one. I believe the answer is number 1. Annie, you believe? Okay, I'll go for number 1. Frankano says so. Yes, if he is a dependent and over 80 years. Imana Bwachusu says number 1. The next one here, Mabel says number 2. Number 2 says no, because the MIR is for Ama and a sponsor or partner to meet. The next one here, we have Louisa Sante as number 1 as the answer from Louisa. The next one, Mavis Amoa. Mavis says it's number 3. Yes, because her son is part of the application. Okay. Lyndon Tiamwa, number 1. Let's look at, I'll choose one, a child team. Okay, well, we'll choose one for you. No worries. Yes, if he is dependent, our team says so. Then the next one here, 3, Vivian Teria says number 3, because her son is part of the application. Answer is 1, Ricky Bochwe says so. Okay, now the next one here, so I will call for 2. Lordina Ment, you call for 2? Okay, well, let's see. Uncle Ben will give us the right answer. Besma Martin says number 3. So it's either 1, 2, or 3. Let's see what you have. Yes, uncle, because her son is part of the family and his salary or way can be considered as part of their family income. You were clear on this last Saturday. Daniela says so. Okay, well, answer is 3. Charles Jenny says answer is 3. We go to the next one. Josephine says number 1. Next answer, number 3, Georgia Sari. Okay, the next one, Doreen Mochia Wusu, number 1. I think it's 2. Linda Osei says so. The next one here says Eric Yaboa, number 1. Okay. Number 3, Evelyn Asima. I'll go with 1. Yes, if he's a dependent of over 18 years old, David Samoa says so. So you're going with 1. Well, the next answer says number 1, Samuel Mreku provides that answer. Ebenezer Muamu says A, which is number 1. Doris Kessie says number 1. Okay, good. Let's keep going. Nyakua Amwa, number 1. You provided that on Facebook. Thank you very much. Joseph Akoli, number 3, which is C. Tilly Duma says number 1. And okay, Nyame Obolo, I'll take yours as the last one as number 1. Uncle Ben.
Well, so let's go back to the nuggets. That should give us our answer. And normally when you're looking at these cases, you have to look at the 2 together. So we know that for the child to be able to support the parents to meet the minimum income requirement, the child has to be 18 and it has to be a dependent. Those are the 2 qualifications. Let's go back and see our first child, which is our first junior. So Amahofe, we know that she came with a child when the child was 17. Then they were given 2.5 years from 2002 to 2004. So, 2022 to 2024. is 2 years, 7 years plus 2 years is 19. So the child is above 18. And AMA, their income is 17,800. They're short by what? 5,400. He's earning 10,000. Is it a dependent? Yes, because it's part of the application. Now, those people who are saying number 3, you've only taken one
part of it. Okay.
You didn't consider the age. So if you say because he's part of the application, if a child who is 16 is part of the application, would you use the income? And that is why people fail in exams, because you don't combine the whole answer or solution to the answer. So the answer is 1.
So those of you who said as 1 income from a dependent whose child or a dependent child who is over 18 can be added to the parent's income to meet the minimum income requirement. So anytime you see MIR, that is the minimum income requirement. Well, that's that for another test of our knowledge this week. Another one will drop in the community on all the social media platforms late or early next week, I should say. And we will be coming up with that later in the program to have this explanation on there. So now let's go over to Uncle Ben's desk and find out what it is that we discussed today with a brief summary.
Yeah, so today we've discussed a concept that people have used as part of calculating their lawful residence towards the 10 years. And that is that when an application is rejected, they are able to make a valid application without 14 days. Now, obviously, the new law, which is the long residence requirement, says that that period of applying within 14 days after an invalid application will not count towards the qualifying period. The court, in the case of AFZA, said that paragraph 39E is a shield and not a sword, which means that it protects you from becoming an illegal migrant, but it doesn't count towards your 10 years lawful residence. So when you're making an application for 10 years lawful residence, if you have ever had a rejected application or overstayed for a period but made the application within 14 days, that period will not count towards your lawful residence. The reason why I say that is this. Somebody may have limited leave valid until maybe 20th of March. And then on the 4th of April, they realize that their visa has expired. 20th of March to the 4th is about 15 days. If they make the application, even a day after it expired, although they've made it within 14 days, they've overstayed. And the 14 days covers their lawful residence and continuity of residence, but it doesn't give them the benefit of using it as adding up to the 10 years. Thank you very much.
And
our address, the e-visa one I said.
And with that, I come to the end of the whole story for today. We have been discussing how to look and calculate the number of days that do not count towards your long residence. The new 10-year long residence will no longer accept overstaying towards the qualifying period. And Uncle Ben has graciously taken us through that. We want to say thank you to you for your time, your consent, your questions, and your participation. And to the lawyers and all the workers at BWF Solicitors, I thank you for your support and your sponsorship. To Uncle Ben for your time and dedication to the community. To my studio producer, Professor Day, to Sheila Ankra and Padmo Dudu for the admin and aesthetic work, and to everybody that's been part of it. We want to say thank you so very much. We'll be back again with you same time next week with another edition of the Community and the Law. But remember, if you have any question, you have any concern, you want to find a lawyer, please go to the 4th floor of the Anna House. BWF Solicitors is there, 214-218 Tottenham High Road, 7 Sisters, London N15 4NP. And again, let me also remind you, if you want to register for the e-visa, go to .gov.uk and search for e-visa. You can just put in the search engine e-visa registration and you'll be taken to that link. Click on it. If you have any difficulty, as I said, speak to BWF solicitors and they'll help you. My name is Ore Kufrimpon. Have a good evening.